Okay. Attorney Concepcion.
Yes, Chief Justice.
No, I was just trying to lighten the moment because you seem already tired. But I would like you to think of the complicated nature of the questions that are before us. If I would allow you to imagine a particular situation that I and the other justices of this court could very well be faced with. I have a very good clerk, for example, and this clerk helps prepare the agenda that is going to be deliberated upon by the Supreme Court. Now, this clerk is therefore involved in a very confidential function. That clerk can actually sell information about our agenda items, and people know that there are buyers of information about confidential matters in this court. Can you imagine that?
Yes,
Okay.
Your Honor.
In a buyer's market, that clerk can pass on information that can be sold for $10,000, $20,000, $50,000, depending on what kind of information we are talking about. That is why we are very, very strict with the confidentiality of our proceedings. Do you understand that?
Yes, Your Honor.
Because it is important for the administration of justice for our proceedings to be kept confidential.
Yes,
Okay.
Your Honor.
But that clerk is only salary grade 6. That means that the salary of that clerk of the Supreme Court, whom I value very much, and whom I entrust with the safety of confidential information of national importance that could actually be sold to corrupt people for a lot of money, salary grade 6 will only yield that clerk 10,000 pesos a month. Okay? Can you imagine that?
Yes, Your Honor.
Now, I have noticed that this clerk has been absent lately. And so I do not wish to lose that clerk. Because of the honesty of that person, I call in that clerk and ask her what has been the problem. And she shares with me the fact that she has too many children to attend to. Would you have an idea how much the rental of a very small 6-square unit in an informal dwellers community would command right now? Assuming that that clerk lives within the Metro Manila area. Would you have an idea?
5,000?
Yes, correct. So from a 10,000 peso basic salary, that clerk, after some deductions, of course very minimal because that is a very small annual income, would only bring home a net of 4,000 plus. But if you are going to deduct operating expenses, that leaves a net of 2,000 plus to that clerk.
Yes, yes.
And I value that clerk, but I cannot increase, we cannot, none of us, not even the 15 of us, can increase her salary because we have to follow the salary standardization law, much as we want to. And we are in danger of losing the services of a very good clerk because her take-home pay is so small. You understand?
Yes, Your Honor.
Her problem is she has so many children. And I ask her, why do you have so many children? And she says, ma'am, may asawa po ako. Am I committing an impeachable offense if I tell her, bakit hindi ka mag-family planning?
Yes, Your Honor.
Yes, I am committing an impeachable offense.
Yes.
If I had asked the clerk kung bakit hindi siya mag-family planning?
No, I don't think so. I mean, I don't think you're committing an impeachable offense because are you referring to a violation of the Constitution?
Yes, because you're saying that the state has the duty to protect the life of the unborn, which is from the moment of fertilization.
Yes,
Now,
Your Honor.
you're saying that all contraceptive pills has a third action, which is to prevent implantation. So if I'm telling her, go and see a medical doctor in a government clinic and ask for a contraceptive pill, am I committing a violation of the Constitution by asking a government employee to cause the non-implantation of a fertilized ovum?
If Your Honor, please, I think the employee will have to be informed of the consequences of...
So your legal problem is only with the information. If therefore it is only the right to information, and the medical doctor in that government clinic says, if you take this contraception pill, it has the third action, and she says yes, am I and she violating the Constitution?
Yes, Your Honor.
We are both violating the Constitution simply because I asked her to go to a family, to a doctor, to ask her about the contraceptive pill?
The person who actually uses contraceptive, Your Honor, knowing that it could cause the abortion of her
What
fertilized
if
ovum.
she says she is not getting young? An additional pregnancy is already deleterious to her health. Is she committing a violation of the Constitution?
It means that, she still continues to do what she wants to do without concern for...
No, don't worry about the concern.
That's why, Your Honor.
The question is simple. She feels, because of her many children and her work here in the Supreme Court, if she continues to have children, in the long run, it will be very dangerous to her health. Is she violating the Constitution?
I would think so, yes.
So
yes, Your Honor.
there is a constitutional duty of a woman to expose herself to health risks as long as the fertilized ovum is not prevented from being implanted.
Okay, right now, Your Honor, the contraceptives are not illegal.
No, that's simple. Is there therefore, because if you are saying there is a violation of the Constitution, then there must be a duty. Is there a duty on the part of the woman who believes that her health is already being exposed to risks to continue allowing such risks to attend her?
Yes.
Because she will not do anything to prevent the implantation of a fertilized ovum in the womb.
Okay, Section 12 says the state shall equally protect the life of the mother and the life of the unborn.
How
so
is
it's
that
the state, Your Honor.
That's the Justice Bersamin has already asked you. The Constitution says they are of equal importance. But everything that you have basically said is focused on the primacy of the right of a fertilized ovum.
Yes, Your
to
Honor.
be implanted.
Yes.
You are saying it is primacy. So the interpretation is that there is primacy, but the Constitution uses the word equality. What are we going to use?
Well, if Your Honor, please, it depends. No, if you're talking of the life of the woman, because she is she's getting old.
Day, she feels that she can't even eat properly. She's even in danger of losing her job. It is obvious to her that her physical condition, her material condition is deteriorating, and she receives this advice. Does she now have the constitutional duty to ensure that a fertilized ovum is implanted in her womb?
I think, yes, Your Honor, she has to make sure that the baby inside her is also protected, because the baby has as much right to her life inside her, and she has that responsibility.
Let's read section 12 again. You forget that there are two other sentences in section 12. Do you have section 12 with you?
Yes.
Okay, read it from the beginning.
Okay, only have the second sentence.
No, you cannot read a
I know.
constitution in a chopped manner.
Yes.
You have the duty to make sure that the context is complete.
Yes, I will do
Okay,
that.
where is it? Please read it for us.
Okay, the state recognizes the sanctity of family life and shall protect and strengthen the family as a basic autonomous social institution. It shall equally protect the life of the mother and the life of the unborn from conception. The natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government.
In the third sentence, it is where the word primary is used. The natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government. In
Yes,
other
Your
words, we are talking about several things here. The marriage is the basic social unit as defined in the first section. The second sentence talks about the equality of the right of the mother and the right of the unborn child. The third sentence talks about the ultimate duty of the parents with the support of the state to rear the youth for moral and civic efficiency.
Yes,
Which
Your
means that there is a goal. And the goal is to enable that kind of quality rearing to take place. Now, the children of this clerk of mine cannot anymore be cared for because they are too many. Is she now violating her duty under the third sentence of the Constitution under Section 12, Article 2?
The presumption, if I may, Your Honor, the presumption of the question is that it's the duty of the woman, whereas Section 12 really refers to the duty of the state.
The duty of the natural, again, read it again, please. The natural right and duty of the parents, first, in the rearing, will be supported by the state.
Yes.
So to whom
Yes,
is the right and duty? To whom does it belong? The parents. Then, in the pursuit of that right and duty, the state shall support the parents. That's the order of things.
Yes, Your Honor.
Okay. In which case, basically, you are saying that the woman who is receiving only 10,000 pesos a month and whose husband probably does not earn so much is now required to put her life at peril in order to ensure that any fertilized ovum that results from a sexual act with a husband is not prevented from being implanted in her womb, even if it endangers her life, and even if an additional child will effectively prevent her from exercising her right and her duty. You are saying that?
If Your Honor, please, the presumption is there are no other available family planning methods except for contraceptives. But there are other family planning methods which will not harm the life of the mother and the life of the unborn. So in that case, both of their lives will be equally protected. And, I think that woman should be prudently advised to consider other methods other than contraceptives that will, achieve what she wants or will address her problems, but not endanger her life as well as endanger
That
the life of the
woman
unborn.
at home, and many of our employees are in this situation, lives in Fairview. When she gets to Fairview, it is already 8 o'clock. Pagod na. The only time that she can see her husband will be a few hours. And then, in order to follow the natural family planning, she uses the tulak system. Okay, tulak system, you push your husband away. Is that promotive of the first sentence of Section 12? What will happen? What will happen? And let's be frank about it. Will the husband appreciate a woman who pushes his wife, who pushes him away?
Well, if the husband is considerate enough, then, and probably it's how the woman makes the tulak, then...
A tulak is a tulak. Huh?
Well, I think, if I may say this, Your Honor, the first sentence is so much deeper than that. I mean, I think it's when you say the sanctity of family life and strengthen the family, it's not just based on that aspect of the married life.
The sanctity of family life requires that both partners in such a marital relationship have the means to explore each other as husband and wife. That is how I understand it from a practical point of view.
Yes, probably, if you're honest, that's a practical point of view, but I think that's
not... In other words, what I understand is, you have set a very inordinately high bar for every woman to grapple with her conscience under such economic conditions without giving a way out for her in this situation. You see, the kind of advice I could actually be giving would be the advice that many of us would be giving our employees whom we are already seeing are in dire poverty conditions. They are not born out of a desire to violate the Constitution, but they are born out of a desire to be compassionate to the conditions of those who are living in such situations.
If Your Honor, please, I'm setting the high bar insofar as the state is concerned, because it's the state's duty to address poverty. And it's the state's duty to provide jobs.
All right. So we go again. Do you believe that we are supposed to read the provisions of the Constitution in balance and not isolate one sentence as against the three sentences
Your Honor.
in the section and one section against the other sections? Okay, I'll ask you to go again to another provision of the Constitution. You go to Section 9 of the same declaration. Okay, can you read Section 9, Article 2?
The state shall promote a just and dynamic social order that will ensure the prosperity and independence of the nation and free the people from poverty through policies that provide adequate social services, promote full employment, a rising standard of living, and an improved quality of life for all.
Okay. Now, can this be done in a year?
Depends on the program, Your Honor.
Can this be done in 2 years?
Again, it depends on the program.
Can this be done in 3 years? Has any nation ever accomplished a significant increase in a year?
Increase of?
Well, those standards, those threefold goals of the Constitution, of the economy. Well, what I'm saying is, the complexity of this question could actually be beyond this court to address. First, your argument, and I've read your argument through and through, premises itself solely on statements made by 3 or 4 commissioners in the Constitutional Commission. That's Gascon, Villegas, Davide, and one other perhaps. Okay. Now, in which case, according to the understanding that I'm getting from the drift of Justice Carpio's question, was an extreme reaction to a solution that actually was already found by the fact that Roe versus Wade can never happen in this jurisdiction because of the phraseology of Section 12. Without going to the extreme interpretation that conception immediately, no, not extreme, but at this point, it was not then fully debated, that conception starts from the moment of fertilization. In other words, because Roe versus Wade is a situation that was already way into the pregnancy, it can never happen in the Philippines. But in an extreme, where you were saying, in an abundance of caution, some commissioners happen to have made a statement that it starts from fertilization. Then we go back to the question of Justice Peralta. What was the people's interpretation at the time they ratified the Constitution? If you are going to use the tool of contemporaneous construction by the acts of the people, where an overwhelming majority favor the use of modern artificial methods, then that is one way of interpreting how they see the Constitution to be. I don't think that the people will allow that their future be determined only by statements made by 4 people. But you see, the problem that we have is we have to even balance all of these constitutional goals together. And for all you know, the question may not even be before us. You understand the complexity?
Yes, Your Honor.
In other words, what we really want is a more layered approach to your arguments than just making use of these statements of 4 people. We are looking at how we can substitute our own judgment for the judgment of Congress and the judgment of the President that this is the way forward for our people. We are 15 unelected people. Most of us are beyond childbearing years. I'm sorry. Okay. So it would not really hit us personally. But we want to be very clear about our own constitutional duties. Because, okay, there were snide remarks here you can ignore. Because I then have to ask you the question. If artificial contraception had been here, why has it not been criminalized so far?
If Your Honor, please, may I just ask a question regarding the previous point that you raised, Your Honor?
Yes.
You said, I'm getting the impression, if Your Honor, please, is my impression that this court is going to disregard the constitutional intent as expressed by the 4 commissioners? Because they have...
Wait. There is no intention to disregard. But what I'm saying is
because that was what they was agreed upon, Your Honor, as a constitutional intent of this Section 12, Your Honor. It was clearly expressed, and they had impassioned debates on that, Your Honor.
Please listen. I am not disagreeing that those statements are on record. There is no disagreement that those statements are on record. But you are forgetting that we have tools of analysis in order to analyze the Constitution.
Yes,
one
of which...
Wait, please.
I apologize, Your
okay?
Honor. I apologize, Your Honor.
And what we are asking for is a more layered approach, because this court is not going to decide one case apart from its very complicated context. Nor is this court minded to just pay attention to one sentence above all, and it's not even a full sentence, but it is only half of a sentence as primary over everything else. That is what I'm asking you to listen to. And that is why I'm asking you to help us balance the right to life of the unborn child from the moment of conception with the other constitutional values that I have already tried to bring out when I was discussing the possible concrete scenario of a poor government worker unable to earn decently for her family and wishing that there was a way to stop the proliferation of the number of children that she has. So it's layered. And usually, decisions of this court take that into context. You understand that?
Yes, Your Honor.
Because you know why? We are not going to answer a theological question here. We are not going to answer a metaphysical question here. The reason why we cannot answer that is we are more humble than wishing to go into the area of defining ultimate morals. The Constitution has already identified for us the proper metes and bounds of our powers, and we dare not go beyond that. Okay, so we go again to those concrete cases. Are we now in a position to supplant the policy approaches and the decisions of Congress in trying to balance its many constitutional goals? Are we in a position to supplant all of those?
If Your Honor, please, our position is that this RH law makes abortion possible. And, of course, that is against our laws, Your Honor. And insofar as Section 12, Article 2 is concerned, it is also our position that the RH law violates Section 2 because of promotion and promotion of contraceptives and the mandate for widespread dissemination and universal access to contraceptives, Your Honor. And
I know your position. I know your position, but you have not answered the question. Are we in a position to supplant the decision of Congress to choose a policy direction, considering the so many interests that have been outlined already in the Declaration of Policies of the RH law? Can we say this is a better way? Are we not limited enough? We are limited, first, because we are unelected, and second, we have already defined metes and bounds.
If Your Honor, please, if there's such a serious assertion of constitutional issue or assertion of unconstitutionality of a law which is present in this
But
case.
the justification is also a constitutional goal. See, that's what the point I have been trying to tell you. We are here trying to balance several constitutional goals. That was the gist of Justice Reyes's questions. Are we a court that can just focus on half of a sentence? Or do we take the whole of the law as it tries to address several policy objectives that are found in the Constitution?
Okay. So far, what I'm getting is that we have this problem. We have the problem of poverty, and we have the problem about being able to make choices, Your Honor. But we also have to consider that what is involved here also is a more fundamental right, which is the right to life of the unborn. So I think the balancing of interests will have to be considered very carefully, Your Honor.
Who are we to say that the poverty approach, alleviation approach of government, and the health protection approach of government is superior? Our approach, their approach is inferior to our moral sense.
If Your Honor, the Constitution is breached, then I think this honorable court has the bounden duty to step in and determine the metes and bounds allowed under the Constitution.
Yeah, because again, we have phrased it carefully already. The Constitution does not say from the moment of fertilization. It says from the moment of conception. And the equality paradigm is there. We cannot disregard that equality paradigm. And we look at the first sentence and the third sentence, and it talks of about a whole plan for the family, which we cannot also ignore. In other words, one way the court can approach this issue is to just say that considering that there are so many competing interests here, we are not in a position to make a factual determination of the questions you have been asking us to make.
Well, our position is, with due respect, Your Honor, I mean, this honorable court doesn't have to make a factual decision because that's already been settled by the Constitutional Commission, because the reason for that is really to protect the life of the unborn from the very inception. And if we know already that inception is at the point of fertilization and not at implantation, which is several days after fertilization, then I think, Your Honor,
Noche, I have to remind you, we are here trying to balance many things. you are harking again to your interpretation of the second half of the second sentence of Section 12. Help us look at other provisions so that we can come up with the right balance. That is what we are trying to be. We're trying to be very careful about our exercise of our constitutional duty. Here.
If Your Honor, please, I can think of Article 3, Section 1. No person shall be deprived of life, liberty, or property without due process of law.
No.
So, the unborn, as we already know, has the right to life, and that life has to be protected and cannot be taken away without due process, even if we say that.
Now, if you are going to be strictly technical about it, the definition of person under the law is that as defined in the Civil Code. A person is defined as either natural or artificial. A natural person becomes a person only when there is viability. So if you are going to use that, you have a problem, a statutory bar. If you're going to use due process, help us look at other options because we are willing and we are open. What we're trying to tell you here is that we have a very complicated situation.
I don't know what other more compelling reason there is than protecting the most fundamental among all human rights, Your Honor. And I think, no one can claim to be here, and we will not be, arguing about this issue.
You know why this question is very important for the country? Is because when you're saying that the life of the unborn starts from the moment of fertilization, if our countrymen, especially women, have been using contraceptive pills for decades, you are basically saying that they have been violating the Constitution from 1987. And is it now the province of the court to make a pronouncement that that is so? And is it now our duty to say that Congress has reneged on its duty by not criminalizing the use of contraceptives? You have placed us in a very difficult situation. And we are open to suggestions, but you must provide a constitutionally viable way for this court to address those questions.
If Your Honor, please, what makes this RH law really despicable is it's the state. It's the state that exercises its power, supposedly to promote the common good. And it's supposed to be a parens patriae, the principle of parens patriae. You protect people who are not able to do anything to remedy their situation. And this should also apply to the unborn. And this is what makes it so despicable. It's the state and that's doing this. This is a state-mandated contraception that makes it so despicable, Your Honor.
Let's go to contraception. You have already looked at the IRR and you saw already the natural and artificial modern methods. Modern contraception methods that are enumerated in the IRR. You have gone through that?
Not through all the...
Okay. Let us go to HH. Paragraph HH of 3.01.
HH.
Okay. Okay?
Yes, Your Honor.
Okay, I'll read it for you so that you can collect your thoughts. Modern methods of family planning refers to safe, effective, non-abortive fashioned and legal methods or health products, whether natural or artificial, that are registered with the Food and Drug Administration as applicable to plan pregnancy. Modern natural methods include Billings ovulation or cervical mucus method, basal body temperature, symptothermal method, standardized method, lactational amenorrhea method, and any other method deemed safe, effective, and natural by the DOH. Have you read that?
Yes, Your Honor.
Okay, you have anything against these?
Against the natural?
Yes.
I suppose.
No.
What do you mean? Anything against
So you will,
how it's written?
You will you will allow and support government's promotion of these natural family planning methods.
I suppose.
Yes?
Yes, Your Honor.
Okay. Modern artificial methods. The following sentence follows. And or health products include oral contraceptive pills. You have said that you say that this is an abortive fashion.
Yes, Your Honor.
Condoms, you have already replied to the question of Justice Bersamin. It's not an abortive fashion.
Yes, Your Honor, it's not.
Injectables,
Abortive fashion, Your Honor.
intrauterine devices,
Abortive fashion.
no scalpel vasectomy,
It's not abortive fashion, but it could be mutilation, Your Honor.
is it or it could be? What does the revised penal code say about mutilation?
Okay, I was holding it earlier, but I don't have it right now.
From
Your
memory,
Honor. It's severing a body part, a reproductive organ or something.
so if you take out that body part, separate it from the person, that's mutilation.
Without any medical reason for doing that, and that may be a mutilation, Your Honor. Without any reason for doing that.
If there is a medical reason,
Well, I suppose it's not mutilation because it's medical
so
surgery.
mastectomy, hysterectomy.
There's no problem with that, I suppose, Your Honor.
Mastectomy is all right.
Yes.
Hysterectomy is all right.
Yes.
Even if it results in the loss of a reproductive organ.
If that's medically required, Your Honor.
So the intent is important before it becomes mutilation.
Yes, Your Honor. Because if there's no reason to do it.
Does the revised penal code talk about intent?
Well, for criminal liability to set in, Your Honor, I think it's important to look into intent.
Does the revised penal code require the element of intent?
Unless it's mala per se, Your Honor.
Okay, so you're not ready for this question, but you have characterized it already as mutilation.
I said it may be mutilation, Your Honor.
Under the law, mutilation is a criminal act.
Yes,
So
Your
you're
Honor.
basically saying that one who has a tubal ligation has committed a violation of the revised penal code? So this is basically your legal conclusions from your arguments. One who has already used oral contraception has already violated the Constitution. One who has had a tubal ligation or a vasectomy is already guilty of violating the revised penal code. Are you asking us to make those legal conclusions?
If Your Honor, please, again.
Yes.
If Your Honor, please, again. It's not the individual that violates the Constitution, because it's a state. The state that has the duty to equally protect the life of the mother and the life of the unborn from conception. So, but the question is premised on whether the individual commits a violation of the Constitution by taking contraceptives. That's not our position, Your Honor. We're questioning Section 12 based on the RH law, and the RH law is the state imposing contraception.
There is no duty on the part of any individual, not even by a Supreme Court justice, to promote only natural family planning methods. It is only the state that is bound. That is your theory?
The state is bound.
No, question. There is no individual duty on the part of any Filipino, including all the justices of the Supreme Court, to promote only natural family planning methods.
No duty, Your Honor.
No duty.
Yes.
It is only the state who has a duty to not promote any method other than a natural family planning method.
I did not say that, Your Honor. Any method that's going to put the life of the unborn at risk, Your Honor. That's the position
So we go to
taking, Your Honor.
condom is all right. A vaginal cup
Yes, I suppose.
as spermicidal it's not only Justice Bersamin who knows some of these things. A spermicidal, you have already considered, is not an abortifacient?
Yes, if it prevents fertilization, then it's contraceptive and not abortive.
Okay, so it is all right for you, for the state to distribute condoms. Okay?
Under the provision.
Yes, no.
Yes.
Okay.
That's under the
It
provision,
is all right
Your Honor.
for you, for the state to distribute vaginal caps.
Yes, Your Honor.
It is all right for you, for the state to distribute spermicidals.
I have to be very honest. I'm not too sure about.
But you
the
should
nature
have,
of
because you're going to
spermicidal.
describe all of these methods to us, because we have a lot of questions in our
Yes.
mind.
I can make a general statement. Those that.
Okay, oral
that
contraceptive
prevent.
pill. Okay. You know that many women right now, even those who are young, in their teens, have the phenomenon called PCOS. You know what PCOS is? Okay. PCOS, it's not a machine. It's the polycystic ovarian syndrome.
Okay. Yes.
Okay? In that situation, there are many cysts that are lining the uterine wall.
Yes, Your Honor.
You know what the medical response to a PCOS situation is? Other than surgery, what is it?
To take the pills.
Correct.
Yes.
So there is a medical reason
There's a medical
for
reason.
this.
Yes, Your Honor.
Okay.
But
Is that therefore prohibited?
no, Your Honor, because usually that's upon advice and disposed upon prescription of a duly licensed physician. So it's monitored, and there's a therapeutic reason, a medical reason for doing it.
So, those medicines that prevent the ovum fertilized from being implanted in the womb are not by themselves prohibited if they serve a medical reason.
Yes, Your Honor. Yes.
But I thought that you said that the primacy of everything is to make sure that the fertilized ovum has a receptacle in the form of and it's a positive duty to make sure that there is nothing that prevents a healthy implantation.
If Your Honor, please, if that medical reason is determined by a physician who supervises the giving, the prescribing
if a physician
of that.
says that the health of my employee is already endangered because if she has additional pregnancies, can that physician prescribe an oral contraceptive pill?
If it's is there a medical reason? I'm sorry.
Her health is deteriorating. Obviously, she cannot bear more.
Just deteriorating, but there's no specific medical reason for
Poor health, little nourishment. She cannot bear anymore to have children. Then that's the condition of many Filipino women. Okay, you are pausing. That gives you a puzzle. That's the reason why I was telling you our situation is complicated and you have to allow us to ask you in a context-layered way and not be shocked at the fact that we are trying to ask questions from a multi-angled perspective.
Yes.
You understand?
Your Honor, I was just reading something, that's why I paused.
Well, you were pausing even before you read it. So, let me now go to a different situation. Infertility. Okay? They go to a fertility clinic and an egg is fertilized with the sperm of the husband. Okay? Assuming that during that menstrual cycle, 2 eggs were extracted. 2. And 2 were equally put in a petri dish. Or even 3. Because the woman took fertility pill. And even 8. Because that is the most number of births that have ever been given in one delivery. 8 eggs. All of those eggs were implanted. And because the man seemed to be at his peak at the time when he was extracted with the sperm, all 8 were successfully fertilized. Okay? Is there a duty to implant all 8 on the woman?
Okay, if Your Honor, please, so sure, there are ova formed already, because so those are persons already, Your Honor, and that's something I've been reading up on this, Your Honor, and that's something that is quite troubling, Your Honor, because what do you do with the rest that will not be implanted, Your Honor?
Yes, that's the question I'm asking you.
Exactly, Your Honor.
Is there a duty to implant all of those 8 on the woman's womb?
I don't know the medical implications on the woman if, all the 8 are going to be implanted there. But then all of those 8 are persons, and, I think also the lives of the 8,
Is there a duty?
will also have to be considered.
Yes, you have to think about whether we can force a woman to receive 8 fertilized eggs. Does a woman have a duty to receive 8 fertilized eggs?
If Your Honor, please, the woman didn't have to get into this situation if she knew exactly what to expect before undergoing this procedure.
She is infertile. She is infertile. And there is always a chance that even with the harvest of the eggs, not all attempts will succeed. They have been trying years and years
Yes,
and years.
precisely.
So she took a fertility pill, 8 eggs were produced, and it has happened.
So
8 were planted on a petri dish. 8 were successfully fertilized. If you are saying that there is a constitutional duty to ensure that there is a receptacle or a womb for life to be viable, for every fertilized ovum, is there now a duty on the part of the woman to allow herself to be compelled to accept 8 fertilized eggs?
let me look at it this way, Your Honor. What are the interests involved here? The interest of the woman to get pregnant. Okay? And the other competing interests here are the lives of 8 human individuals, human persons. So I guess the answer should be very clear, that the lives of the 8 persons we have to ensure that the lives of the 8 persons are protected and preserved, Your Honor.
So between
compared to the choice of the woman.
So there is therefore no equality balancing. The equality word in the second sentence of Section 12 does not mean anything. We're basically saying the primacy of the right of a fertilized ovum to be implanted in a womb is primary and supersedes any other right existing.
It's not that, Your Honor. As Father Bernard said, it's not really of equal importance. No? I mean, that the way it is read is that the life of the mother and the life of the unborn shall be equally protected. So it's not like they both stand on the same ground or same footing. But when instances are such
that's a theoretical statement. I'm asking you a concrete statement. It's not easy to survive a pregnancy with 8 ova inside a womb. Does she have absolutely no right to ensure that she survives?
That she
survives.
The woman survives?
The woman. In other words, are we now saying that the equality spoken of here in the second sentence does not at all have any meaning?
Is it proven that she will not survive if all 8 are implanted, Your Honor?
You see, this is the reason. So she has the burden of proving that she will not survive?
Yes, Your Honor, because all the 8.
She does not even have the right to say, I cannot and will not bear 8 children?
I don't think she has the right to say that to the detriment and to the great prejudice of the 8 human individuals, Your Honor. These are lives that we're talking about, human lives. So, if Your Honor, please, I think we have to be very clear about what Section 12 really protects here.
Okay, so this is what is really before us. The questions that are concrete that I have given you, you have found difficulty answering. The legal statements you have made here as your basis for your petition are statements made outside of a concrete context. Congress has already made a decision, a policy choice. We cannot receive factual evidence.
I was hoping, Your Honor, that this court would take judicial notice of extensive medical findings in medical journals
But these are
and textbooks, Your
all
Honor.
conflicting. The reason why I am posing these difficult questions for you is because we, as justices of the Supreme Court, have to look at those possibilities. We do not decide in a vacuum. We try to anticipate for the future.
If, Your Honor, please, this honorable court has in the past made exceptions, Your Honor, to technical rules of procedure in order to...
No, these are not technical rules of procedure even. The questions of Justice Leonen are technical. Mine is basically a substantive duty on the part of this court to always ensure a balancing of interests. That's why I'm asking you for help in balancing the interests that are before us. What does not help us in the way we need to balance interests here are general statements alone. That's why we test your theory by giving you concrete situations that you need to respond to. And by your responses, it is clear that even you are grappling with these questions because these are very difficult questions, which seems to indicate to us that maybe this court is not the best forum, but this court might need to exercise judicial restraint unless you can show us a constitutional way out of our jumping in the situation and substituting our judgment for that of the Congress and the executive combined. See, we are not closing our minds to anything, but you have to provide the court these tools, because these tools are quite limited to us.
If Your Honor, please, it's not a matter, I think, of this court substituting the judgment of Congress or the executive. I think it's for this court to uphold the supremacy of the Constitution at all times, Your Honor.
We are always trying to do that. Mind you, that's why my question is even in the way I give an advice to my clerk, I am mindful of what the Constitution is saying. That's why I'm asking you, am I already violating the constitutional principle of upholding life from the moment of conception? See, they are not theoretical. They are very concrete, live situations that we ourselves apply to our own day-to-day decisions in our attempt to give fealty to the Constitution. That's why I ask you those specific questions.
But if Your Honor, please, if the Constitutional Commission has already made it clear that the intention is not to leave it to Congress to determine when the beginning of life is,
But you see,
and we Your Honor is not prepared to accept that conception is fertilization, if that's what I get, and you still want to leave it to Congress to determine when human life begins, then I think I will really have difficulty answering your questions, Your Honor.
One problem you have in your petitions is you have not used and shown to us with sufficient clarity that the statements made by the Constitutional Commission by 4 members is determinative, finally, of the question. You see, there are contemporaneous construction materials we need to use. We need to look at the context of the Constitution, and we have to balance this. That is why I was trying to draw out things from you. Please note, I have always been telling you that we are open. But our duty is more nuanced than what you want us to respond to you immediately. And in fact, my questions are basically intended to help you also. Because for all you know, you might be able to draw upon my questions and submit a richer memorandum than you thought was possible.
Yes. I realize
Do not take offense at this. We are not here to try to pin you to only one position. We are trying to test the validity of your arguments.
If Your Honor, please, I beg to disagree that what I have pointed out are just opinions of 4 members of the Constitutional Commission. They were the most active members who debated on this and who participated in the debates, but it doesn't mean that these are their opinion. This was put to a vote, Your Honor, and it's in our reply, Your Honor, how the voting went. So this is the constitutional intent, not just of 4 members of the Constitutional Commission, but of the 1986 Constitutional Commission itself, Your Honor. And if that doesn't warrant the consideration of this honorable court, then it will be very difficult for us to look for other
we never said
support.
We never said we will not consider it. We never said that. None of us ever said that.
Yes,
but
Your
we
Honor,
have
but
been actually trying to draw from you other sources.
Yes, Your
other
Honor.
sources, because you understand that from the very beginning of law school, you are already given a list of the primary sources of law, then you are given tools of interpretation, then you have your lesson on constitutional construction, then you have your lessons on contract interpretation. These are all logical and analytical tools, and that is why I'm trying to draw you. This is to help you, actually. Okay, now, let me now go to another point. Okay. The Justice Velasco has already tried to create a situation where some provisions of the RH law can stand constitutional scrutiny and others cannot. You have, however, said that the law absolutely cannot stand scrutiny. He was saying that the principles that are found all over in many extant provisions of the law itself talk strongly against the use of abortive fashions. Can that not save some provisions of the law, while the others we may be open to striking down? He asked you a fair question, and you said, absolutely not. Now, this is also actually an opening for you to respond in a more broad-minded way when you are already being asked by a justice to make the refined distinctions between sections. What are the most obnoxious sections, and what are the sections that you are willing can be considered as capable of standing constitutional scrutiny? That was actually his question. So would you like to review your answer in that?
Now, Your Honor?
Yes, you are supposed to be an expert on this. That's why you're counsel here.
Yes. As I said, Your Honor, and insofar as hormonal contraceptives are concerned, Your Honor, we have said that they're abortive fashions, Your Honor, unless the present available contraceptives in the market, they've been found to be abortive fashions, Your Honor, and have an abortive character, Your Honor.
You're basically saying that oral contraceptives are abortive fashions because there is nothing in the market that does not have the quality of the safety net, which is the rejection by the womb of the ovum, fertilized ovum that is trying to be implanted.
Yes.
If that third action is not there, and there is a contraceptive pill that only talks of the first 2 actions, are you willing to consider oral contraceptive pills?
If there is such a contraceptive, yes.
Okay. So you are willing to concede that, and are you not willing to concede that the phraseology of Section 9, Section 7, that says that the FDA is hereby authorized to certify that they are not to be for abortive fashion use, that is not sufficient for you as a safeguard? In other words, we are not foreclosing the possibility that there are oral contraceptives with the first 2 actions, without the third action, and the FDA will certify that. Is that not a sufficient safeguard?
May I just point out something, Your Honor? We have a problem there, Your Honor, because if the standard use is that life begins at implantation, then I think that really is completely divergent from Section 12, Article 2, as we espouse it to mean, Your Honor, which is conception equals, is fertilization, which is the beginning of life. And then if we look at the definition of abortifacient in the RH law, and also look at the implementing rules and regulations, there is a radical difference in the definition, because in the IRR, Your Honor, they have inserted the word primarily, Your Honor. When you say...
Okay, let's just focus on the law, because that's what you are bringing before us. Let's take it as a problem, the IRR, later. The Justice Velasco's question again, the law alone.
Yes, Your Honor.
Same question. Can you review your answer, please?
Okay, so hormonal contraceptive. Okay, if the matter is referred to the FDA for proper determination, I think there was a question earlier. I said if there's a basic agreement that life begins at fertilization, then probably FDA can determine whether a contraceptive is abortifacient or not. But then if the standards are different, that life begins at implantation, then we have a basic difference there, Your Honor.
So the law itself, the RH law, apart from the IRR, has not changed the definition, and you're acceptable. You accept the definitions in the law.
Of abortifacient, Your Honor? Yes, yes,
okay.
Your Honor.
So definition of abortifacients under the law is acceptable to you.
Yes, yes,
so
Your Honor.
it's the IRR that you have a problem with.
Yes, yes, Your
okay.
Honor.
Fellow justices, I have no more questions for the first round. I'll turn over the microphone to Justice Carpio.